There were 77 rapes reported in India on a daily basis in 2020. The total number of rapes were 28,046. But it is highly unlikely that these cases reported would involve wives complaining to the police against their husbands for rape. And that's because marital rape is not recognized as a crime in India. The crime of rape is addressed as per Section 375 of the IPC. It lists out 6 descriptions where it can be held that a man committed rape. This is if the act is against the woman's will, without her consent, consent under intimidation and threat, impersonation, when the consent obtained is due to intoxication or unsoundness of mind or through the administration of a substance by the man concerned, and if the woman in question is under 16 years of age with or without consent. But the law has an exception. Initially, sexual intercourse by a man with his own wife, the wife not being under 15 years of age, was not rape. In 2017, the Supreme Court extended this age limit following a petition by a child rights organization to 18. But the exception that practically grants immunity under the rape law for married husbands who rape their wives still stands.
The crime already exists. The ingredients of rape, what constitutes rape, what is the evidentiary standard, all the rest of it already exists in the IPC. That it is a crime, to force sexual intercourse with somebody, to have sexual intercourse without their consent. That crime already exists. Now, if an exception has been carved out, not on the basis of the kind of act that it is, but on the basis of someone's identity or relationship to the victim, striking down that exception as being violative of equality, dignity, liberty, etc., does not amount to creation of a new offense. It amounts to widening the scope of that offense to include not a new category of an act. The act is the same, but to say that the identity of the perpetrator or the relationship of the perpetrator with the victim is not relevant.
On May 11 this year, the Delhi High Court, which was hearing petitions to strike down the marital rape exception under Section 375, delivered a split verdict. Justice Rajiv Shakdher ruled that the exception was unconstitutional and should be struck down. Justice H.C. Harishankar disagreed. The matter therefore remains unresolved, and this will now be taken up by the Supreme Court.
Even after a judgment, after the verdict, there was many articles and many memes. It was flowing on the Instagrams and the Twitter that who was a sex worker, she has the right to deny to say that no to say for sex. Even a sex worker has the right. But even a woman who is a married woman to her husband, she can't able to say that, right? So even I used to see that the split verdict, it is actually able to make it into the judicial review again.
I marked marital rape as an offence because I was not aware of that, and I also objected to that question during my entrance, and in fact it was taken up as an objection. So even an ignorant person can say that it is an offence, so I think it should be considered by at least court.
The Indian Penal Code under Section 376B does criminalize non-consensual sexual intercourse by a man separated from his wife, but the debate around marital rape centers on an existing relationship between husband and wife.
It should be criminalized. The base motive is कि अगर फीमेल मना कर रही है तो चाहे वो शादी के पहले करे या बाद में करे, अगर वो फोर्स्ड है तो it is not right and it should be penalized. क्योंकि a no is a no, चाहे वो शादी के पहले हो या बाद में हो.
A wife is not a thing, and she also had their own independence other than the husband's. So in my point of view, marital rape should be criminalized.
If you're creating a law and it goes against the particular gender or a particular segment of society, then it's not serving the ultimate purpose of justice. So it is important that we should create a balance. We should provide a protection to the women and even after the marriage, but same time it is important that government should check on the misuse of it.
So if something is done without your consent, I think it is not, it doesn't go well. So, but it cannot be penalized as such, because after marriage, of course, once you are there in this relationship, I think basic understanding, all these things put together form your marriage.
It must be implemented, so there is no question about it. It's directly related to the rights of the women. Even if you are a married woman or somebody is married woman, but she has some rights. She has equal rights. She has, she is the sovereign over her body. So in that situation, even the husband has no right to take that kind of decision without the will and consent.
I look at this matter a bit differently because it involves your personal bedroom. In personal bedroom, you don't have any evidence, and all laws are based on evidence.
हर बात के दो पहलू होते हैं, उसके सकारात्मक भी होते हैं और नकारात्मक भी. मेरे हिसाब से अगर इसमें होगा, मतलब बहुत सारे केस झूठे होते हैं, मतलब तो इसमें क्या ही कहा जा सकता है. मेरे हिसाब से फिर भी होना चाहिए, जो जिस प्रकार से अत्याचार होते हैं महिलाओं पे.
Marital relation, if you can say, then you need not to put any law on that. But once you say marital rape, rape is a rape. Either it's a marital or without marriage.
मतलब बंद दरवाज़ों के पीछे तो मैरिज लाइफ तो एक अपनी वो एक अंदरूनी वही होती है ना, वो तो आंतरिक रिलेशंस हैं, वो जग जाहिर तो वैसे भी नहीं होने चाहिए.
There has been a robust debate in India for quite some time now on the criminalization of marital rape. In 2013, the Justice Verma Committee set up to look into strengthening anti-rape laws in India after the Nirbhaya incident recommended that marital rape be criminalized. Justice Verma in his recommendation had also cited various international precedents. This included the United Kingdom, Canada, South Africa and Australia, where marital rape had been outlawed, and also the European Commission of Human Rights in the CR versus UK case, where it was held that a rapist is a rapist regardless of his relationship with the victim. Justice Verma said, and I quote, "The exemption for marital rape stems from a long outdated notion of marriage which regarded wives as no more than a property of their husbands. According to the common law of coverture, a wife was deemed to have consented at the time of marriage to have intercourse with her husband at his whim. Moreover, this consent could not be revoked." Stop quote.
The countries that we are comparing ourselves to, which have criminalized marital rape, first of all, most have a gender neutral provision. Consent for them is not a factor that only women can withdraw, a man could withdraw as well. And second thing, there are no blanket, applications along with their rape laws, like we are asking for it in India. There are various separations, there are various differentiations that are there for they call spousal violence over sexual violence over there. They do not call, a lot of countries do not call it marital rape. So some countries have an embargo that you cannot file a complaint after 30 days. Some countries have much different punishments than what a stranger rape would entail. So there are a lot of differentiations in other countries that have criminalized marital rape.
A fair point, though I don't think it is relevant to the issue of marital rape. It seems more of a deflection. It is certainly something that can be raised separately and the courts can examine. I do think, however, that it speaks to a double standard on the part of those who support this exception being retained, that they think it is judicial overreach for the court to strike the exception down as unconstitutional, but they do not think it is judicial overreach to say that the court should examine whether or not the provision should be gender neutral. So there is a double standard there, and I think it points to the fact that this argument is not being made by them in good faith. It is being made by them as a distraction. Having said that, I think it's a fair point, and the courts can certainly look at whether or not gender neutrality is something that this country is ready for, and whether not having it violates constitutional norms.
जनरल कंसेंट मिल जाता है शादी के बाद वाइफ से कि हमारी शादी हो गई तो जनरल कंसेंट मिल गया, कि हमारी शादी होने के बाद मतलब है ना कि वुमेन की पूरी बॉडी पे आपको अधिकार मिल गया. तो ऐसा नहीं होना चाहिए कि एक बार अगर वुमेन ना कर दे तो फिर ना है ना, फिर वो या तो वाइफ हो या कोई भी जनरल लड़की हो, तो जनरल लड़की क्यों हो और वाइफ में क्यों डिफरेंस करना चाहिए. अब देखते हैं सुप्रीम कोर्ट क्या कहती है, लेकिन मेरे हिसाब से क्या है, ऐसे कॉमन मैन कि कोई भी पढ़ा लिखा आदमी हो उसके हिसाब से ऐसा होना चाहिए कि वो मतलब वो क्या, आप खुद को देख लो, अपनी बहनों को देख लो, शादी हो गई तो इसका मतलब ये थोड़ी है कि उनको जनरल कंसेंट नहीं मिलना चाहिए, बस इतना ही है।
भले ही शादी हो चुकी है नहीं हो चुकी है, बट इट इज़ अगेंस्ट द कंसेंट, सो ऑब्वियसली इट इज़ सपोज टू बी कंसिडर्ड एज अ क्राइम एंड even if the rapist here is the husband, he is a criminal. I have this question कि rape करने की ज़रूरत ही क्यों पड़ रही है? Why is it not consensual? Why is the woman's decision is not mattering here? Just because she is married does not mean कि आप rape कर सकते हो और उसको ये कह सकते हैं कि सिर्फ ये शादीशुदा है तो ये rape नहीं है. Rape तो rape ही है.
दिल्ली में इट्स फैमिलियर है सबके साथ कि हाँ दे नो कि व्हाट मैरिटल रेप इज़ राइट, बट गांव में किसी को ये पता नहीं है. सो लॉ में ये चीज़ आनी चाहिए.
हमारे देश में जो शादियाँ होती है बहुत ज़्यादा फोर्स में होती है, बहुत सारी फैमिलीज़ कल्चर्स ये सारे काम करते हैं, तो जब शादियाँ होती है तो उसमें आई थिंक 20% तो लड़कियों की रजामंदी नहीं होती है. उनके बाद शादी के बाद ऐसा कल्चर एक्सेप्ट करे कि हाँ उन्हें रिलेशनशिप में आना पड़ेगा, फिजिकल रिलेशन में, तो आई थिंक ये गलत है. अगर लड़की परमिशन देती है, लड़के की भी परमिशन है, देन अगर वो लोग रिलेशन में जाते हैं तो ठीक है. अगर लड़की मना करती है तो आई थिंक फिर उसे नहीं जाना चाहिए. और आई थिंक we accept this sentences, no means no.
Justice Shakder of the Delhi High Court agreed that the removal of this exception was necessary to reflect the changing times. Moreover, he believed that the exemption not only denied women legal recourse under the rape law, but also agency over their bodies. He agreed with the contention of the petitioners that rape is rape, that rapists are rapists, and that the crime ought to be recognized as such, even if the rapist in question was the husband. He deemed the exception unconstitutional against Article 14, which is the right to equality, and said in his concluding statement, and I quote, "It is time all stakeholders bit the bullet. It would be tragic if a married woman's call for justice is not heard even 162 years since the enactment of the IPC. To my mind, self-assured and good men have nothing to fear if this change is sustained. If I were to hazard a guess, those amongst us who want status quo to continue would perhaps want to have marital rape exemption struck down if the victim involved was his or her mother, sister or daughter." Stop quote. Justice Shakder also cited the National Family Health Survey from 2016 that threw up some worrying numbers. It included the percentage of married women who experienced spousal violence. 5.4% of the women said they had been forced against their will to have sexual intercourse by their husbands. 2.5% said they were forced by their husband to perform sexual acts against their will, and 3.6% said they had been forced with threats to perform sexual acts against their will. But that is one view. Those against the striking down of the exemption are not in denial about the fact that some husbands sexually abuse their wives. They acknowledge the absence of consent, but are against the removal of the exception for a whole host of reasons. Firstly, that this is a decision that is to be taken by the legislature and not the courts, because removing the exception would be tantamount to creating a new offence in the statute books of marital rape.
Sexual violence within marriage is already has provisions to be penalized in India. It can be punished under the Domestic Violence Act. It can be punished under Section 498A of Indian Penal Code, and it is also punishable under Section 377 of the IPC. So no, I do not think that the exception in Section 375 should be struck down. And if at all there is a need, or there is felt a need to bring rape within the purview of marriage, then I think the legislature should sit down and deliberate on what kind of law can take care of that.
Moreover, a distinction ought to be drawn between marital relationships and others, as in the former, there is an expectation of the fulfillment of conjugal rights on the part of both the husband and the wife. Another concern is the possibility of misuse, as none other than the Supreme Court has in the past taken note of the misuse of the laws in India against domestic violence as well as dowry. The legislature, in its wisdom, has decided to retain the exemption, realizing its implications for society and the institution of marriage.
Anybody who says that misuse of law is no reason to not bring a law, my question to them is, first of all, please cite a section of the Indian Penal Code which has been misused as much as the Section 498A of Indian Penal Code, which criminalizes cruelty within marriage. There are cases where any kind of dispute, and when I say any, it means any. I just finished counseling a family yesterday who had come to me, and I had, after going through all the evidences, realized that the only grudge of the woman in this marriage was that the husband used to work for long hours and was not giving her time. Whether that can be a criminal offense or not, I leave it up to people. Definitely misuse of law is no ground not to bring a law, but it is the legislature and it's the lawmakers' responsibility that any law that they bring should not become a weapon, which the crime against women sections have sort of become today because they're so easy to abuse.
If it is a false, baseless allegation which is proved in court that it wasn't an actual rape, then the man is still going to suffer a lot in terms of his credibility, his financial stability, because then she can file for grounds of divorce in a very and make it very ugly for the man. And I mean, I'm not saying that it should be just looked at in a financial or a social cost to the person, but it can swing either ways, and that's why it's a very sensitive topic, and I think we need much more clarity on this topic rather than getting emotionally charged on this whole issue right now.
The idea that there are going to be false cases or there are going to be false accusations is something that is with every law, something that is there throughout everything. Just because there is exploitation or there is something that is a law is being exploited, or even democracy for that matter is being exploited in certain rights, so it does not mean we should not have democracy. So we should start somewhere. Taking an initiative and just waiting would not suffice. I think it's just a matter of whether a woman is giving consent or not, whether it's be to a husband or a partner or anybody for that matter. And I think at 75, India at 75 has grown enough to understand that a woman's consent matters.
जब शादी होगी तो वो रेप कैसा? पहली बात तो अगर आप शादी कर लेते हो, किसी से विवाह के संबंध में बन जाते हो, तो आप उसे रेप कैसे कह सकते हो? ठीक है ना? हस्बैंड वाइफ की रजामंदी से ही होता है वो तो, और उसको मैरिटल रेप की संज्ञा देना, वो उसके क्राइटेरिया हो सकते हैं कुछ, जैसे कि कोई महिला आरोप लगा दे कि मुझे फिज़िकल वायलेंस कर रहा है, तो उसकी तो पुलिस कंप्लेंट हो जाती है. बट अगर कोई कहते हैं मैरिटल रेप, तो ये मेरी समझ से परे है कि भैया शादी के बाद रेप कैसा.
A woman should have complete 110% autonomy on her body. A rape is a rape, no matter when, where, how, because of whom, with whom. A rape is a rape, and a bad touch is a bad touch.
The counter view also stated that when making international comparisons, one must also note that those laws are gender neutral, unlike Section 375 in India. Finally, provisions of the Domestic Violence Act can be invoked if there is sexual abuse. Section 3D Part 2 of the Domestic Violence Act covers sexual abuse, which includes any conduct of sexual nature that abuses, humiliates, degrades, or otherwise violates the dignity of women. The counter to this is that the Domestic Violence Act only attracts civil remedies, though it has been argued that under Section 19(2) of the Act, a magistrate can pass orders for the registration of an FIR as well. Justice Hari Shankar, in his verdict, which called for the retention of the exemption, said in the context of the expectation of the fulfillment of conjugal rights in a married relationship, and I quote, "If therefore a man in such a situation requests her on a particular occasion to have sex, he is exercising a right that vests in him by marriage and requests his wife to discharge an obligation which too devolves on her by marriage. If the wife refuses and the husband nonetheless has sex with her, howsoever one may disapprove the act, it cannot be equated with the act of ravishing by a stranger. Nor can the impact on the wife in such a situation be equated with the impact of a woman who is raped by a stranger." Stop quote.
I think this is a hopelessly outdated view taken by Justice Hari Shankar. One, there is no expectation that the concept of conjugal rights itself is one that should be struck down by the courts. And this matter is in fact already pending before the Supreme Court. And I hope that the Supreme Court does in fact strike down provisions for restitution of conjugal rights that exist across personal laws. Also, we need to move beyond the idea that conjugal rights or sexual relations take place only within the confines of a marriage. You know, the sexual relations and marriages no longer necessarily go hand in hand. Courts themselves recognize live-in relationships need not even be something as committed as a live-in relationship. Whether it is a one-night stand, a live-in relationship, or a marriage, ideas of consent do not get altered. And there's no expectation of consent in perpetuity. And there should not be any expectation of consent in perpetuity. Even if one has an expectation or a hope of conjugal rights, the remedy when that hope or expectation is not met is not to rape your wife. If you are feeling so that you really, your expectations of this marriage have not been met, then there's the reason why, there's a ground for divorce. But rape is certainly not the solution.
Justice Hari Shankar also said, and I quote, "These obligations or expectations do not, needless to say, entitle the husband or coerce or force his wife into sex against her or his will, which learned counsel for the petitioners erroneously seem to assume to be the implication of the impugned exception. At the same time, these obligations, expectations and considerations, which are completely absent in the case of a stranger who seeks sexual congress, do constitute a sufficient basis for the legislature to distinguish qualitatively between an incident of non-consensual sex within the marital sphere and without it. In view of these several distinguishing features that mark out the relationship between the husband and the wife and its dynamics both within and outside the confines of the bedroom as sui generis, if the legislature has desired not to characterize husbands as rapists, I completely fail to see how the court can hold otherwise." Stop quote.
Question of this amounting to judicial overreach doesn't really arise. It is very much the job of the judiciary to examine laws that are brought to it, that are challenged before it, to see whether or not they stand the test of constitutionality. Right? That is the job of the judiciary, to see whether a particular legislation, passed by Parliament, or that is, deemed to be passed by Parliament, approved by Parliament, whether or not it meets the test of fundamental rights and other constitutional obligations. So to not do that would amount to abandonment of, one's duty by the judiciary. It is not the other way around.
The centre did not submit a detailed response on its stand, except saying that any change to the existing law will have wide societal ramifications. As Justice Hari Shankar also said, the legislature in its wisdom retained the exemption over time because it did not want the relationship of marriage to be discoloured by the taint of rape.
I don't know why somebody would make that statement unless they believe that the institution of marriage is founded on rape, that rape is an integral part of married life. It is only when you believe that does the idea of marital rape threaten that institution. But if you really believe that that institution has value to society, to families, for children, etc., then you need to do your best to preserve that institution. And preserve does not mean preserve as it was in the past. Preserve means reform it, modernize it, so that it is adaptable and it survives other social changes that are taking place. That's the only way you can really ensure that the institution of marriage, if you do think it is valuable, that it survives. And you need to, if there is a history of marriage that is part of the history of the social institution of marriage, is certainly founded on patriarchy and inequality. And you need to remove that. You need to reform that if you want the institution of marriage to survive.
The fundamental question, though, is there are men who rape their wives. Should they not be taken to task with the full might of the law for that act of rape, instead of the wife having to rely on provisions of the Domestic Violence Act, which may still not accord her justice to the fullest extent for a crime of that nature? While the sanctity of marriage should be respected, and so should the expectation of conjugal rights, can coercion, force and physical abuse, including rape, be tolerated and remain unacknowledged by law because it is a marital relationship? These are questions that will be asked again before the Supreme Court as well. For now, the decision remains split.